Welcome to the November 2025 edition of This Month in Payroll. I'm Claire Soccio, National Leader of PwC's Workforce Practice. This month we will discuss the annual reports issued by the Fair Work Ombudsman and the Fair Work Commission, highlighting their respective activities over the past year and intended areas of focus for the year ahead. The preservation of paid parental leave under new legislation known as Baby Priya's Law, and the full court decision in a case between the Fair Work Ombudsman and Baker's Delight that considers the reverse onus of proof for franchisors. Firstly, to the annual reports of our two key workplace regulators. The officers of the Fair Work Ombudsman and the Fair Work Commission both reported another big year, marked by targeted enforcement, major reforms taking effect, and continuing signals for employers about governance and risk. The Ombudsman's headline remains the scale of underpayments returned to workers. In the year to 30 June 2025, the agency recovered over $358 million for more than 249,000 employees, supported by a new strategic enforcement model and an emphasis on resolving disputes quickly where cooperation is possible. The new operating model aims to proactively address the root causes of non-compliance and is supported by a three-tiered compliance and enforcement policy, which first seeks to encourage voluntary compliance through education and advice, then to guide compliance where direction is required, and to enforce compliance only when it is in the public interest. Large corporates were highlighted again for systems and governance failings, accounting for about 60% or $213 million of this year's recoveries. The Ombudsman points to cultural, governance and leadership deficits resulting in systemic underpayments. Applying what it describes as the strategic deployment of its enforcement toolkit, the Office filed 73 litigations, issued 743 infringement notices for record-keeping or payslip breaches, which attracted penalties of $838,000, and issued 1,220 compliance notices, which recovered $8.2 million for 3,500 workers. 8 enforceable undertakings, 4 of which relate to universities, delivered more than $47 million in back pay. This was a considerable decrease from the 15 undertakings entered in the prior year. Courts also imposed record penalties, including $15.3 million against the operators of Sushi Bay for deliberate underpayments, a significant 50% increase on the prior record penalties. Resolution at scale occurred outside the courts, with 18,570 workplace disputes completed and over 2,000 workers recovering more than $7.3 million through dispute assistance services. As we well know, the criminalisation of intentional wage underpayments took effect from 1 January 2025. To support its new jurisdiction, the Ombudsman established a criminal investigation branch, built interagency arrangements with the Australian Federal Police and Commonwealth Department of Public Prosecution, and published a guide on cooperation agreements. The annual report outlines the priority high-risk sectors for the year ahead, which will be proactively targeted with data and intelligence. They remain unchanged from the past couple of years and include large corporates, universities, aged care services, disability support services, fast food restaurants and cafes, building and construction, and agriculture. So what are the key takeaways for employers? Payroll governance remains a board-level risk. Proactive inspections and intelligence-led campaigns are the new normal, and transparent cooperation with the Ombudsman is expected. Supply chain responsibility is also tightening, so businesses contracting out work should take additional steps to verify compliance across its tiers, especially where labour hire is prevalent. Turning now to the Fair Work Commission, which closed the year ended 30 June 2025 with over 44,000 lodgements, up 10% from the prior year. Unfair dismissal cases remained the largest category, representing over a third of lodgements. Reform delivery by the Commission was extensive. In August 2024, it assumed new functions for regulated workers, which are employee-like workers and road transport contractors, including minimum standards, agreement registration, and unfair deactivation or termination remedies. It also implemented changes to casual employment, including the new definition and conversion pathway, and the right to disconnect for non-small business employers. The revised statutory test for whether an employment relationship exists, which centres on the real substance, practical reality, and true nature of the relationship, now applies under the Fair Work Act, with opt-out available for certain high-income contractors. The Commission completed the 2025 annual wage review, finalised new model terms for enterprise agreements, including flexibility, consultation and disputes, and progressed its work on gender undervaluation in modern awards. For labour hire, it granted the first regulated labour hire arrangement orders, showing how same job, same pay requirements will operate in contested contexts. The report also highlighted the Commission's user access and technology modernisation, including the rebuilt Modern Awards pay database, which went live in June 2025. Through their respective annual reports, both agencies have signalled a similar message that compliance is about culture, systems and design. The Ombudsman's strategic enforcement approach and the Commission's user-centred process reforms are converging on prevention, fast remediation and targeted deterrence. For employers, the priority remains unchanged. Invest in payroll governance and accuracy across the ecosystem, including for supply chains and labour hire arrangements. With the continuing maturity and sophistication of the regulators, the year ahead is likely to reward those who get ahead of governance and engage constructively if issues arise. And before I move on, a quick note that the Commission and Ombudsman jointly launched excellent new online learning content this month, covering foundational information about bargaining, enterprise agreements and pay and entitlements. These are highly recommended resources to support payroll teams' continuing professional development. This month saw baby Priya's bill passed into law, inserting a new protection into the Fair Work Act to preserve employer-funded paid parental leave in the tragic circumstances where a child is stillborn or dies. In simple terms, if an employee would have been entitled to employer-funded paid parental leave but for the loss, the employer must not refuse or cancel that leave unless the employee asks to do so, or employment terms expressly provide otherwise or allow for other specific leave. The protection extends to birth, adoption and surrogacy arrangements and applies in the unfortunate event of a loss occurring on or after 7th of November 2025. For clarity, the change does not require employers to offer employer-funded paid parental leave. Employees remain entitled to unpaid parental leave under the National Employment Standards and to government-funded parental leave pay. This change applies where employer-funded leave is otherwise offered and ensures that employers cannot cancel or refuse it because of the loss. If paid leave has not previously been provided in these circumstances, employers need to move quickly to review and update relevant policies and employment contract templates, and to ensure managers are trained and ready to handle any sensitive disclosures promptly and appropriately. HR and payroll teams should clarify any intersections with unpaid parental leave and compassionate leave, and ensure leave approval, payroll configuration, and communications are aligned to the new rules. Now to a recent federal court appeal decision that clarifies how it can be possible for a franchisor to be held responsible for a franchisee's wage contraventions under the Fair Work Act. This case began back in early 2023, when the Fair Work Ombudsman brought civil penalty proceedings against a Baker's Delight franchisee that operated 3 stores in Tasmania. It alleged widespread underpayments to the tune of $1.2 million and breaches of leave, record keeping and payslip obligations. That franchisee later entered liquidation and ceased to participate in the proceedings. The Ombudsman then pursued an argument that Baker's Delight, as the responsible franchisor, bore the burden of disproving the allegations and that it was liable for half of the franchisee's alleged underpayment. There were two key concepts at play here. The reverse onus provisions at Section 557C of the Fair Work Act mean that an employer bears the burden of disproving an underpayment allegation where adequate records or payslips have not been created and retained. If an allegation cannot be disproved and a contravention is established, Section 558B allows a franchisor to be held liable for a franchisee's contraventions if they knew or should reasonably have known the violations would happen. A similar provision applies to holding companies in respect of its subsidiaries. In this case, Baker's Delight ran an argument that because franchisors are not the employer, the Ombudsman could not rely on the reverse onus provisions. In December 2023, the Federal Court disagreed and found in favour of the Ombudsman, a decision that was upheld last month on appeal to the full court. The case against Baker's Delight, as the responsible franchisor, is now able to proceed without the Ombudsman having to separately prove the franchisee's contraventions. In reaching its decision, the full court characterised the franchisor liability laws as a tailored form of accessorial liability, aimed at situations where franchisors have a significant degree of influence or control over a franchisee's affairs, and where they knew or could reasonably be expected to have known that contraventions would occur, or that similar breaches were likely. While a reasonable steps defence is available, it is assessed against the franchisor's size, resources, influence, compliance arrangements, and complaints handling systems. So what are the lessons for franchisors and, by extension, for holding companies of subsidiaries? Firstly, don't assume the reverse onus only applies in proceedings directly against the employer. Where it is applied to prove a franchisee's contraventions, the franchisor, or possibly holding company, can be held accountable for the breach. Secondly, franchisors and holding companies should expect close scrutiny of their capacity to influence the payroll and record-keeping practices of franchisees and subsidiaries, and their knowledge of risks and issues in the network. And while it may be possible to disprove a franchisee's or subsidiary's contraventions, the more sustainable pathway is, of course, ensuring robust compliance and preventative systems are in place. Franchisors and holding companies can take proactive steps to prioritise network-wide compliance that meets the reasonable steps threshold. This might include a framework with clear standards and audits for record-keeping and pay slips, proactive reviews of payroll compliance, ongoing monitoring and analytics to identify anomalies, accessible channels for employee complaints and whistleblowing, training for franchisees or subsidiaries on awards, enterprise agreements and NES entitlements, and documented escalation and remediation processes. Agreements and policies should encourage and require compliance, and central oversight should be evidenced. Before we close, a quick mention about our Workforce Leaders Forum, which was held earlier this month and focused entirely on the very topical payday super. It was a great discussion with valuable insights about the actions needed now to prepare for the successful transition into this new regime from 1 July next year. If you haven't yet viewed this forum, you can watch on demand via the link in your covering email or through our website. And that's it for our November edition of This Month in Payroll, and for the year, as there won't be a December edition. This final episode for 2025 is being released on Rowan Getty's last official day with PwC. And I would like to recognise and thank him for his enormous contribution to the payroll community and for establishing and being my long-standing co-host on this series. Rowan, you will be dearly missed. And I warmly welcome Alana Haydock, who will co-host this series with me going forward. You'll first hear from Alana in our January 2026 edition. Best wishes from Rowan, Alana and me for the rundown to year end. And thank you for your continued support throughout the year, both listening to this update and attending our Workforce Leaders Forums. If you would like to revisit any of our prior updates, they're available on our website at pwc.com.au/payroll. And if you have any questions or need for support, please reach out to me or your usual PwC contact. Until next time, Have a great month in payroll.